Hello, my fellow MSSNY 2023 delegates. My name is Alex Staunschlager. I'm a urologist in New York City. Because of the limitations of the House of Delegates format with only 60 seconds to discuss a resolution, I want to take a few minutes of your valuable time to address the Resolution 259, State Enforcement of Self-Insured ERISA Plans, Rutledge SCOTUS, referring to the Supreme Court of the United States decision in the Rutledge litigation. I want to provide you with sufficient background information to make an informed decision and support this resolution with the original resolved and to pass it immediately without delay. The healthcare system in the United States is very complicated, and I want to give a little background on the different health plans that operate in the United States and how different rules apply to all of them, or each of them, to be more precise. This is a Supreme Court decision. I believe it's a unanimous decision. Maybe the only time that the Supreme Court ruled against a health plan. So that's a very important decision. It negated 50 years of previous litigation. It made it irrelevant. So there are new rules on the block that appeared in 2020 that are applicable to ERISA plans. And I will explain what ERISA plans are and why you should care. The healthcare system in the United States is incredibly complex. According to the official statistics, there are more than 60,000 commercial plans in the United States. About 25 of them are self-insured plans, which means even if United Healthcare, Cigna, or Aetna says on the card, the actual legal plan is not Aetna or Cigna, but usually the employer. So, for example, MSSNY might have a MSSNY health plan for which it may be legally responsible. In addition, there are 30,000 fully insured plans in the commercial market. All these self-insured plans are governed by a federal law called ERISA, which was called by many as one of the worst laws ever, because it was not created for healthcare, it was created for retirement benefits. In addition to that, there are more than 4,000 Medicare Advantage and Medicaid plans in the United States. All of them have different rules and regulations and separate prior authorization requirements, for example. This page provides the summary of the different plans that operate in the United States. There are government plans such as Medicaid, Medicare, as well as federal employee health plans that are administered by Blue Cross, Cigna, etc. There's also TRICARE, which is, Veteran Affairs Health Plan. In addition, there are state-governed health plans. Usually, these are health plans that are purchased through the exchange. They are typically fully insured health plans. Some employer plans are fully insured, and they would also fall under state law. State law in New York, for example, requires that health plans pay a certain amount in interest charges when they don't pay on time. On the other hand, ERISA law is a federal law that governs self-insured plans. About 50 to 70% of commercial plans are self-insured. These are usually employer-based insurance plans. So there is a tremendous number of these plans, and they don't have to follow the regular rules. In fact, they do not have to pay interest even if they fail to pay you for a year or two or three, because ERISA does not require them to pay late interest on unpaid bills, on unpaid charges or claims. They also can create their own prior authorization requirements. They can create their own rules in what's covered and how you appeal denied claims, for example. In fact, the problem is so severe because each of these ERISA plans can make their own rules, that in March 25, 22 letter from Cigna to CMS about electronic prior authorization standards, Cigna said that it cannot even control these plans itself, even though it administers them, and the health plans use Cigna on their health benefit cards. So patient comes with a Cigna card, but Cigna has no control over them. It said clearly, for example, coverage guidelines may be set by an employer group and utilization management companies, and health insurance may be unable to change such guidelines, health insurers being Cigna. So Rutledge may be the ultimate solution to administrative burdens in healthcare. It may be the only time insurance company lost at the Supreme Court. What Rutledge Supreme Court case said is that essentially state governments can regulate self-employed ERISA plans in certain circumstances. There are a few criteria that that the state law needs to meet. One, the rule should not selectively pick on particular plans. The law should apply to all health plans universally without naming any particular health plans. Currently, New York State laws exclude ERISA plans by the fact that they name various health plans, such as, Obama health plans, Medicaid, Medicare separately. So if New York State goes away with naming all these plans, which it did before because it could not regulate ERISA plans, but now it can. And if the rules do not apply to benefits, but only to administrative issues, so New York State cannot say to United Healthcare that it must cover MRI of the head for prostate cancer patients, right? So these are clinical benefit decisions. They cannot regulate this, but they can regulate administrative issues related to these plans, such as prompt payment, interest, clawbacks, denial rights, prior authorization. All of that is fair game. So the Supreme Court ruling is actually a very simple and straightforward. It's beautifully written in a very accessible language. I think any physician would be able to understand what it says, and it clearly states what my resolution communicates, that New York State can adjust its laws to be compliant with Rutledge versus Pharmaceutical Care Management Association Supreme Court ruling, and then it can regulate many aspects of these literally unregulated ERISA plans. There is no downside to adopting this resolution. It's very straightforward. It's based on the verbiage of the Supreme Court law. There is no cost in terms of downside to MSSNY. It will be used as part of the regular advocacy in Albany and education of our lawmakers. Medical practice is suffering currently from the disaster that the ERISA plans are imposing on physician practices. This would provide an outlet. The Congress has failed to reform ERISA for the past 50 years. Going back to the Clinton term in the White House, the Department of Labor, as well as the AMA, and many other organizations were trying to reform ERISA, but there is a lot of resistance because this law that is very one-sided on the side of the health plans and against physicians and patients has a lot of resistance in Washington in terms of amending. It's unlikely that it will be amended in Washington, D.C. So we should use our power at MSSNY to adopt this resolution as soon as possible without delay and start working on getting New York State Department of Financial Services to regulate these plans. It will help us with prior authorization, it will help us with prompt payment and appeals. If you have any questions, I'd be happy to discuss this further.